His Lordship, Justice Anthony Mrima, Her Ladyship, Justice Dr. Frida Mugambi, for hearing of application on petition E565 of 2024 and E522 of 2024.
I guess we have taken the quorum.
Yes, my lord, the court assistant circulated a list and we all put in our names.
Is there any preliminary issue before we proceed? We have received a letter through the office of the Deputy Registrar that the 9th respondent intends to provide video evidence. We mentioned this because so that to let you know that we received that letter, but at the same time, I think this court is properly moved, not by way of a letter, but by way of an application. And therefore, the advocate for the 9th respondent will treat that as just a letter.
My lords, the only issue that I can think of is allocation of time.
Yes, Council, we are doing right that. This is how we will proceed with the hearing of the applications. Yes, Council.
My lords, your ladyship, on Friday, when the court gave directions on how to proceed today, as my lord, the presiding judge observed, perhaps all of us have been working very hard the previous day. So the court left rather quickly when I was on my feet. And I was standing up to draw this honorable court's attention to the fact that no directions had been issued in respect of an application which is on record, which is a contempt application in the Kerugoya matter, where the judge, your brother, in the Kerugoya matter, directed that because of the urgency of the matter, and that he had referred the file to the Chief Justice, that application for contempt, which was on record, would be argued before the bench to be constituted by the Chief Justice. So that application continues to be on record. Give directions on its hearing and disposal. Because as we all know, a contempt ordinarily is not permitted. Audience before purging the content. Can we have your directions for that content application to be heard and determined? I thank you.
What is the date of the application?
Muge, where are these people with the content?
My lady and my lords, my name is Muge for the third petitioner. Now, my lady, that contempt application is dated 9th October 2024.
Thank you.
Yes.
Now, this is how we'll proceed in the matter. The matter is coming up today for hearing of the application, that is application for conservatory orders and the one to set aside. We gave directions last week. We will proceed with those applications. At the end of the hearing of those applications today, we will give directions on the hearing of the application for contempt. So for purposes of going forward, those petitioners who file applications for conservatory orders, we gather them as the applicants, and each of them will have 15 minutes. If there will be need for more time, we will consider as and when. And then any party in support of the application for interim reliefs will have 5 minutes each. Respondents, who are the applicants in the applications to set aside, will each have 10 minutes. And those in support will have 5 minutes. And then the applicants will have 10 minutes each in rejoinder. Interested parties, will give them 5 minutes each. And if senior counsel, Mr. Dr. Amino is around, we will consider his plea.
Meloja.
My lord, if I may pray, that in view of your directions in regard to the contempt application, we would like it placed on record. In view of the holding in the Supreme Court case of Republic versus Ahmad, Abolathi Mohammed and another, that any application for contempt, just like a preliminary objection, should be heard before any other matters. In view of that holding, my lords, we would like that placed on record that you have decided that we hear the potential contemners before the court in the face of that contempt application.
My lord, I think the court has given a direction, and our position on that is that if counsel is unhappy with the directions you've just given, he knows what to do. We have spent far too much time running away from the business of the day. This matter was certified urgent several days ago. It seems on the 9th of October that when the applications before you was certified urgent, we came here, the other side scuttled the date when we came with what turned out to be a frivolous issues about empanelment. When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court in Kerugoya, whereas the court in Kerugoya fixed a date for the application now before you, it did not fix a date for the application. Now you're being told to jump the queue. And if that be the case, then we must take it. It did not impress the court in Kirinyaga as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were toward my lord, we too, the party representatives, filed a PO, and you've not heard me telling you that that PO should start. I'm just following the directions being given by the court. And when all is said and done, my lord, the Swahili say, akili ni nywele, kila mtu akona zake. Nobody needs a brain in this court to know that the reason for all these dilatory tactics is because this side believes, having obtained a final ex parte order, they can now guide the wheels and backpedal and buy time until the conversion of the Jews, or until, as my people say, donkeys grow horns. The court must rein in these tactics.
My Lord, permit me, please, to object to the term frivolous. We have been raising issues we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous point.
Thank you, Senior Counsel.
My Lord Presiding Judge, permit me, speaking on behalf of the ninth petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Mrima, and my Lord, the comments that have been made by my senior, Dr. Muthomi Thiankolu. My Lord, indeed, there is a preliminary objection that we were served by counsel representing Professor Kithure Kindiki, a PU. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Mrima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction or the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we go to any other matter or business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and two others.
Thank you.
Thank you.
Thank you very much.
My Lord, is it possible that we just proceed?
We
Frivolous is
just Counsel, we don't use that kind of language. I think Senior Counsel Paul testified that frivolous proceedings are not in this court. They may be elsewhere, but not here. My Lord Justice Mrima will give directions.
We proceed as a directed, applicants.
My Lord, I was on my feet. This is on behalf of the petitioners on the issues of time allocation. My Lord, the respondents have, throughout this matter that has been going on, sought to have a time allocation scheme whose effect would be to guard the petitioners from presenting their case. My Lord, in the normal course of things, and this is a bench, one of the 50th or 70th bench that we are hearing before, the first business of the court before the directions of hearings are given, which we thought we could do on Friday, has always been what is the estimations of the advocates of the time that is necessary for them to do fair representation within the meaning of Article 50 of the Constitution. My Lord, we are here, we know the urgency of the matter. But as petitioners, on that issues of time allocation, the petitioners wants to plead and beseech the court that each of the application by the petitioners, we shall need 1 hour each to carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record.
I'm sorry to interject. Start with your 20 minutes. If they're not enough, we will consider. We're here. You shouldn't worry about time.
My Lord, for purposes of that issue, if I could just finish, the problem that we have, because we need to organize ourselves, that the time that has been given, one is going to do this and the other. Why that is absolutely important is that at this particular stage, because this has been a recurring thing, that there is instructions to be carried out. This is a court of record. We would want a fair allocation of time from the inception so that we are able to feel that at the end of the day, we did not refer to the court as a substandard case or an incomplete case. So it is only the minimum fairness that we should have.
My Lord, may I say something on the issue of time before the court gives directions?
Let time not be the issue here. Advocate Ongaya, please sit down. Let time not be the issue here. Time can be availed. We can be here the whole of this day. We can be here the whole of this day. So let time not be the issue of discomfort. We will give you the time you want.
Thank you so much, my Lord. That's an impressive direction.
My Lord, Your Ladyship, the sole purpose of conservatory orders to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords, your leadership, to be the bench, what the judiciary is what the people of Kenya look up to hold the country together in terms of observance of the Constitution and of the rule of law. The people of Kenya, in electing the deputy president and the president and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. And it is for this court to ensure that we do not go back to the imperial presidency, where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague, Elisha Ongoya.
My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ongoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you halt implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also put on record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We had filed some written submissions on 22nd October 2024. We adopt and reiterate the contents of those submissions. When we retire, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled petitioners' submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions. My lords will remember the words of the late Justice Chunlal Magwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered that no, we were still waiting long to get our national IDs. We were still waiting long to get our passports. We were still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 74 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find whatever the scope of interpretations, the following will fit into them. Number one, it must have been to give the process optimum transparency. Number two, it must have been to give the process optimum accountability. Number three, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, to the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October, the process between 1st October, when a notice of motion was given in the National Assembly, to 17th October, when a resolution was taken by the Senate, had pretenses, half-hearted pretenses of public participation. That will demonstrate. The process on 18th October, buoyed by any lack of checks, buoyed by the fact that any attempt at checking the institutions had not yielded fruit, now they became brazen. They now undertook a process on 18th October, now completely without any pretense of public participation. There is no single Kenyan who was given a chance to ever say what their take is on Honorable Kithure Kindiki, my law lecturer of yesteryears and a fundamental scholar, my good people. No Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts. No email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely, no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. I think if they are doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024. In that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I'll not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the President himself. The President of the Republic of Kenya undertook these clearances overnight.